I had a requisition slip, my lord. I filed an IA in the other bench. I think 1 and 2 was my item with for the other bench.
Oh, that bench will be after this.
Oh, my lord. The requisition could be allowed, I could bring it up. I had filed it on the 11th.
You can't allow here.
My lord. Appreciate it.
Item 1 for orders. Review petition 68/21.
Nameless Lordship. My lord, we have read to review the order that at 10/11/20, page 19. And side by side, we have also stated that the order passed by learned tribunal is also not free from defects. So that is to some extent we have discussed. Now here, Lordship would see page 21. Exhibit 1 is the electronically generated extract of electoral roll of 1965, showing the name of...
If you can tell us what is the error apparent on the face of record, we will proceed, because if you are arguing on all the points on merit, then you'll have to tell us that you are arguing or you are re-hearing the writ petition on merit.
My submission is these are public documents, and public documents should be believed. But the way the earlier decision was given, my lord, we have some reservation on those observations because it is already exhibited. And it is 1965 document, which is the core document so far these types of cases are concerned. So, and this person is the father of the present petitioner. And so far, the linkage between the two, the learned tribunal as well as this Honorable High Court, regarding linkage, we have some submission that there is the land document of the present petitioner. Kindly see page 55. Here Abdul Kalam Ahmed, he is the DW2. He is the DW2 who is my brother. And Fatima Vidova is the present petitioner. Now both of these brothers and sisters' name have been recorded in the Jamabandi. Now kindly see page 56. 56. Operative portion, page 57. Serial number 11, DW2, Abdul Kader's name is there. And present petitioner, Fatima Bidhova's name is also there. Her name appears as serial number 13, and DW2, Abdul Kalam's name appears as serial number 11. So, linkage is otherwise established. And Abdul Kalam has said that the petitioner Bidhova, Fatima Bidhova is my sister. So the linkage between the two, brother and sister, connects with Abdul Kader, their common father. whose name appears in the voter list of 1965 and 1970. So my humble opinion is this: apart from other documents, when the core documents are there, that should be believed. Section 20 of the IPC names certain versus Section 20. So this should be believed well. Thereafter, not only that, there are some other documents also.
What is
That is
section 20 IPC?
Section 20, I think IPC. Let me clarify this. So these are the officers. If they give any certificate, those are public document. Let me show this exact. Section 21. 21. Of course, well, there's a mistake. But here 20, 12 officers' names are here. 12 officers' names are section 21. Here would say public servant denote a person falling under any of the descriptions hereinafter following, namely, every commissioned officer in the military, every judge, including any person empowered by law to discharge, whether by himself or as a member of any body of persons, any adjudicatory function. So here, I think this third will come. Third will come, and also 11th will come. Every person who holds any office in virtue of which he empowered to prepare, publish, maintain, or revise an electoral roll, or to conduct an election or part of an election. So, electoral rolls are here. And this Jamabandi has been issued by an officer who is authorized under law to issue Jamabandi. That is the cycle officer.
Where is the name of the petitioner in the page 56?
These things are discussed, Lordship, in page
Page
23.
56 starts, page 57 is operative portion.
Serial numbers.
Serial number 11, Abul Kalam.
Who is he?
He is my brother.
Son of
Abdul Kader.
then number 12.
Number
12. Serial number 12.
Abdul Kashem, son of Abdul Kader.
Who is he?
He is also my brother.
Where have you stated? Anyway, number 13.
13 by I myself.
What is the daughter of?
Daughter of Abdul Kader.
Where do you read Kadir?
Public. So far regarding so far regarding objection against a document shall be raised at the initial stage. So before the tribunal, my lord, these documents which were exhibited were not controverted. In one judgment, the Honorable Supreme Court Section 35 evidence একটু ভারী বলছে। So, my lords, my prayer is this. Objection, any objection, it is said Honorable Supreme Court, 2024, 12 SCC 360, para 11 and 12. Here it is said, any objection regarding a document must be at the trial stage, not thereafter. So, in the instant case, no strong objection is raised regarding the veracity of those exhibited documents.
When was the order when was the time dictated? Which year?
It is said that three 519.
Which year is the reference?
Reference is earlier, but my lord, that will perhaps, in my opinion, that will not affect my case because, oh my lord, let me satisfy you, because necessity is the mother of invention. Earlier, I was unaware that there would be a foreigner's case against me, so those documents have to be collected and should be stored in my almirah or etc. But when the reference was made, I had to appear, I had to submit documents. So at that time, I have collected this. Now, that is not the question. Whether it is genuine or not, that is the question.
There must be, you should have produced the copy of the order of the central officer. That this is the order which was passed, depending my name.
No, definitely, my lord, there is an order.
We are not even doing the excel.
My lord.
In these proceedings, the burden is on you. you will have to bring more material
My
in
lord.
support of your content.
My lord, what is my opinion is this. This is a Jamabandi. This has been issued in view of section 50 of the Assam Land and Revenue Regulation. So, there is an order. After the order, this is issued. Of course, order is not here.
Mr. Mahmood, in this, while dealing with this bench, I have repeated this story for more than 100 times. I am repeating it again today. There was if you search in your mobile, you will find out. If you can't search, your junior can find it out. There was a famous BMW murder case. And in that, after half of the trial was over, somebody came into police station, said that, no, I was the driver. Therefore, please arrest me and please punish me. So this happened during the course of trial. Now, the question is,
Very small submission.
if somebody comes and tells us that A is the father of B, in this proceeding, we are asking how you prove it. Is an oral evidence sufficient? We ask you that question. Then you said that, no, we'll answer it later.
Well, oral evidence supported with document.
What document?
That is
Jamabandi.
Namjari.
In Jamabandi, now we'll, in a lighter note, we'll tell you, you please look behind, there are so many learned counsels sitting. I have learned it from, we have heard it in this one very famous serial, where there is an option to call for the friends, to call friend. You can speak to a friend and then give an answer. So behind you are many lawyers. We ask anyone to read the Jamabandi, because we are reading so and so, son of unknown. You say that the father's name is there.
Yes,
You say
father
that this
name-
document, you say that this document itself is a proof. So in our copy, at least you have annexed his Jamabandi is the name against the person is unknown.
No, the father's name is here. Kindly see page 57.
Yes.
Father's name is there. Serial number 11 and 13.
Okay. If you don't phone a friend, we'll ask someone.
Yes.
Mr. Sharma, you have a copy of the
Yes.
Give it to Mr. Sharma. Serial number 13 is the entry. Is not clear,
Not clear.
but Mr. Mahmood said this is what do you call this? So-and-so.
Fatima Bidhova.
So-and-so, Bidhwa.
Fatima
Bidhwa Abdul Kader unknown.
Abdul Kader. Here क्या है
Abdul Kader unknown.
unknown.
In every name's last unknown is written, not
No.
only this.
Not in the first. First page 56 is not there. It comes after this unknown.
Yes, 48 unknown.
From serial number 19, 21, 20, then 11, 12, 13.
My lord, I leave it your lordship. Whether name is written, but letter of the name unknown. Is it a relevant word?
First entry is Thakurali.
Is an evidence for what? Some
Linkage.
person by the name of the petitioner
Yes.
is the owner or has been mutated with a plot of land.
Yes.
Right? You want to link it to say that you are the sister of one of the persons, co-owners of the land, and whose father and your father are one and the same.
Yes.
This was done in 2019.
Yes.
Now you were born in 65, 66.
Not 13%.
Even if we accept
No,
that this
no,
document
no.
shows that the land belongs to you,
Unknown.
how do you explain from 66 or 65 to 19?
That I have said, my lord, necessity is the mother of invention.
So you should have invented more ideas.
Now I have submitted, if your lordship may accept or may reject, but I am submitting
You
this.
are trying to invite court to exercise review jurisdiction.
My
Review
submission is
no
that,
use
my
of-
lord, whether it is genuine or false, that is the
No,
important
that is
question.
not the issue. The issue is where is the error apparent on the face of the record? Or is it a case that in spite of due diligence, you could not have laid your hands on a particular document which has come to you later and which it goes in support of your contentions to a great extent. This is a preponderance of probabilities. These are
Yes.
probable. It's
Yes.
probable that the petitioner had land. But the question is, where was she from 66 to 19? You say you were married, certified by the Gaupura, countersigned by the BDO,
Yes.
never examined before the court, tribunal. The fact that
But that was not done. I cannot do what is not done. How I can say? I am on record only.
No. If you cannot do, then how can we help you
But
find the error? Error
there
must
are
be
some
there.
other documents also. In voter list,
No, tell me, tell us first, in your written statement, have you given the date of death of your father?
my lord. I do not, my lord, want, because it is a review petition, I have limited discover, I know that.
Then second, no, that's not the end of it. Our questions are not ending. First is that if this W is subject to correction by you, we did not find the date of birth. Did you introduce your two brothers at serial number 11 and 12 here in your written statement? We don't find it. Number 3, come to page 67. This is your this is the court recording of the deposition. Here you don't state that your father has died. Late is not there. Abdul Qadir Ali.
That is not there. That is not there.
Because you must introduce that.
And this people is LTI. She is LTI.
Oh, we know many people who are LTI and they are very famous.
No, I leave to your lordship.
One of the persons I have read somewhere, an LTI, he is now India's one top 10 industrialist. Only an LTI. Many of us must have parents who were LTI and groomed us up to be here in court.
Where your lordships have pointed out, those are not pointed out by in the tribunals. So whether at High Court, they can take the benefit or a case of remand.
Abdul Qadir, no? Not Abdul Qadir. Next unknown. Ariyat case is approved by the reportation approved by so. Translate for 9. This is where next date to transfer for 9. Unknown. Unknown means other. Unknown. Yes, yes. Abdul Qadir. Fatima Bashir, Mirta Abdul Kader.
Supreme Court. My lord, my last submissions on law points only. 2004 12 SCC 360, 2004 12 SCC 360, para 11 and 12. That is the Food Corporation of India versus Assam State Cooperative Marketing and Consumer Federation Limited. Here, my lord, I am giving some short description only. Letters forming part of chain of correspondence and official record tendered evidence without objection from opposite party. A receipt of letters also not disputed by such party. Documents held proved and their contents can be read in evidence. So Lordship would see that whether it is applicable in my case, because the other side did not raise the objections which my lords have raised here. Next, my lord, this High Court is a court of record. That is 2000. I am minimizing the time of the Honorable Court. 2001 SCC 666, para 14, 2000, 2000, volume 1, SCC 666. Here, it is said the power of High Court is a court of record. After 100 years, it would be read. Paragraph 14, 17. So, M.M. Thomas versus State of Kerala. Miller? Yes. That is my submission. subject to your lordships. No, yes, that is said the court of record may at any time to correct and also on subsequent developments. Because my name as well as my brother sister's name have been recorded in NRC. NRC was made by house to house enumeration by the enumerators. So that is perhaps more authentic. Officers was house to house. Then again, my lord. My lord. Yes. Yes. We have met. Yes, 8, para 10. From the last two lines it may be read. But the landed tribunal has failed to consider all this and also disbelieved voter list of 66 and 1970 where her father's name has been recorded as Afsar Ali and her own name has been appeared in the draft NRC 2018 and passed a cryptic order which is totally unacceptable.
No, Mr. Mahmood, please complete the chain. In your written statement, did you place it in the evidence? Was it there?
No, that is not there.
Not
Because
there.
at that time NRC was not completed. But Honorable Supreme Court has said subsequent developments may be also considered by the High Court at the time of disposing of review petition.
This, you are referring to an NRC of 2018. You filed this writ petition in 2020. Was it pleaded there?
Yes, review petition is filed
No, not review petition.
2021.
2020 is the writ petition. The writ petition, have you referred it?
No, writ petition it was not there.
It's not there.
In a review petition we have met.
No, it's okay. You went to the Supreme Court. You have the copy of SLP with you. Do you have a copy of SLP with you?
SLP's copy is not there, but order of the Supreme Court is here.
No. Order is something we can read. We wanted to know if before the Supreme Court, you have gone and told the Supreme Court that I have a copy of NRC.
Supreme Court's order we have annexed.
No, that we have read. We have been reading this a lot of times. Whenever it comes, we read that. But tell us, in the Supreme Court, have you said that?
Well, not every person does not think alike. Every person does not. Yes.
You see, Mr. Mahmood, what we are asking, even if it is irrelevant for you, it is relevant for us because we are to author the order, not you.
Yes.
So when
We
you
have
are asking
annexed.
your question, either you say yes or no.
SLP's copy is not with me.
It's
Only
not
the
with
order is with me.
Which page is that?
Page 27. Last part may be seen. Accordingly,
That is why, you see, this is from page 27 that we are asking question. After this cause title, Fatima Bidhawa versus Union of India,
yes.
you will find next for admission and IR and IA exemption for filing of OT, IA exemption from filing of affidavit, IA permission to file additional documents and facts. Now, was this additional documents and facts cover that NRC? We wanted to know only that.
I have no idea. But my last submission, my lord, as there are some questions to be considered,
Now tell me, you were at page 27, the order of the Supreme Court. Please come to that order again. Your present review petition is a creature of this order. Correct? Now, has the Supreme Court said that in the review petition, we give you liberty to produce additional documents?
well, that is not given.
They're not.
That is not given. But this is normally parties rely upon. My last submission, my lord, still, my lord, there are some documents which otherwise show that I am an Indian, though I could not prove properly. So may it be sent back for remand. That is my last prayer.
President, no. Mr. Ali Mahmood goes to the question. Okay, that's also for the respondents. You want to say anything?
Lordship has already pointed out, only aspect is that Lordship, in page 27, Lordship, page 23, Lordship, Jamabandi part was clearly discussed, Lordship. On perusal of evidence and exhibited documents before the tribunal from records, it is seen that the petitioner relied on Exhibit 1 and 2 to prove that she is the daughter of Abdul Kader Ali, who is the son of Kader Ali. However, by Exhibit 8, the copy of Jamabandi exhibited by the petitioner projected 3 plots of land covered by DAG number 280, 281, 296 and periodic pata number 64 situated at village Pota under Porupeta Revenue Circle, where inherited by the petitioner and her siblings. It is projected therein that the petitioner's name appears in the serial number 13 of the said copy and Jamabandi. However, on close scrutiny, it is seen that the name of the one patta holder, namely Abdul Kader, is shown to be son of Sagar Ali, whereas Lordship, this aspect is discussed, Lordship, in this case. And regarding
getting the track, Sagar Ali means
Sagar Ali means his projected grandfather, but whereas he nowhere stated that Lordship, his projected grandfather is Sagar Ali, but he claiming his. Yes, Lordship, that part is discussed, Lordship. Yes, Lordship. And Lordship, it is submitted by the Learned Council, para 5, appearing for the petitioner that Kader Ali and Sagar Ali are one and the same person, and who was the grandfather of the petitioner. So that part was discussed, Lordship. And Lordship, regarding NRC part, Lordship.
just a minute. Just
Not equal lordship kindly permits me, my lord. I am going to quote number 9
Yes.
of lord. My junior would be here.
Then lordship in review petition lordship May 78 of 2021 held by this honorable court on lordship 26 September 2022. Lordship para 20 and 21 is important lordship in this regard lordship.
So we're not following you.
Lordship review petition, earlier review petition lordship Muslim Uddin alias Muslim Sheikh lordship. Page number 17 lordship para 20. Lordship review petition number 78 of 2021.
You're relying on a judgment.
Yes, yes,
Oh,
Lord.
acha. You are reading the brief.
No,
Review petition number
78 of 2021.
decided on
Decided on 26 September 2022.
name of the parties.
MUSLEM Muslim Uddin UDDIN Muslim Uddin alias Muslim Sheikh. Date of 26 September 2022. Lordship, here it is discussed, Lordship, para 20, in So Chandrakante and another versus Sheikh Habib, reported in 1975 1 SCC 674, the parameters under which review jurisdiction is to be exercised has been very lucidly laid down by the apex court. And after that, Lordship, relevant paragraph is quoted there. Then, Lordship, in para 21, it was held that, Lordship, it appears that the review petitioner has sought for fresh hearing of the matter in the guise of a review. It is a settled law that a review is ordinarily permissible only for correction of any error apparent on the face of the record and oblique or for the ends of justice. We find no such error, nor was any such error pointed out by the petitioner. So, under what ground, Lordship, review can be exercised, Lordship? It was mentioned in these two paragraphs, Lordship, and another aspect is there, Lordship. Few lines I am reading. A review of a judgment is a serious step, and reluctant resort to it is proper only where a glaring omission or a patent mistake or like grave error. Yes, Lordship.
Yes.
So Lordship, here I am 20 and 21, I am relying Lordship, and regarding Lordship NRC part, I am relying on this judgment Lordship 2025 SCC online SC 1160.
Please be slow. This is 25, 2021. Then what did you say?
Lordship, regarding NRC part, what learned
NRC.
and your colleague has submitted Lordship.
Here it is 25 SCC online, SC.
SC 1160 Rafiqul Haq ROFIQUL HOQUE. Para number 28, Lordship, after discussions, Lordship, come to the conclusion that Lordship, for the reasons detailed above, the inclusion of the name of the appellant in draft NRC would have no bearing on the order passed by the tribunal affirmed by the High Court declaring the appellant a foreigner. And Lordship, our High Court in a different review case, Lordship.
Yeah, just you're not finished it one.
Yes, yes. So Lordship, regarding NRC part, another important judgment, Lordship, review petition 184 of 2019, para 9.
Review petition number
184 of 2019.
184.
Yes, Lordship.
Decided on a name of parties.
MD full stop, Siraj Ali, SIRAJ ALI, alias Siraj Ali, CHIRAJ ALI.
Date of order.
Date of order 5/12/2024. Just I am reading para 9, Lordship. May I read, Lordship?
Yes.
The learned senior counsel for the petitioner has
Just-
claimed.
Yes.
The learned, para 9, I am reading, Lordship. The learned senior counsel for the petitioners has claimed that the final NRC has been published on 31/8/2019 and in view of the observations made by the apex court in Abdul Quddus Supra, the claim of the petitioners should be re-examined as their relatives had been included in the final NRC. In this regard, it may be seen that the publication of supplementary list of NRC after examination of claims and objections under paragraph 6(3) of the schedule under Rule 4A in bracket 4 of the rules of 2003 is to be done by the local register of citizens registration. Thereafter, Register General of Citizens registration is required to publish the final national register of Indian citizens in the state of Assam. There are no materials placed before us to show that the Register General of Citizen registration has accepted the publication of supplementary list by the local registrar and published the final list. In the absence of such exercise, the final NRC which is relied upon by the petitioners cannot be accepted to be a ground for reviewing the judgment and order dated 31/8/2018 passed by this court. So, Lordship,
That's all.
yes, Lordship. So, my humble submission is that Lordship review is not maintainable. As petitioner sought for fresh hearing of the matter in the guise of review, Lordship.
And you, Mahmood, don't consider the petitioner and also for the respondents. Submissions are completed for the result.
Item 2, review petition 14/23 for orders.
Yes.
Oh.
My privilege. My lord, it is a review petition. It is a review petition against the judgment and order passed by the division bench lordship. The brief fact of the case is this, lordship. There was a plot of land which was taken by the bank after the finishing of the surface proceedings, lordship. And then the land was put on auction. The present petitioner number, he is the retired colonel of the army here, your lordship. And the petitioner number 2 is a housewife, lordship, whose husband is serving in Dubai. Petitioner number 3 is a medical doctor. At present, he is the principal of the Dibrugarh Dental College Lordship. So they had participated, all the three petitioners had participated in the auction sale which was conducted by the Punjab Bank Lordship and become the highest bidder and paid the full amount of the bid amount, that is 1,80,10,000 Lordship. But Lordship, when the bank Lordship repeatedly the petitioner requested the bank hand over the land position. 3 times lot mandals, Kanungo, circle officer went, but the land could not be identified. This happened in 2016 Lordship. So thereafter, when the delivery of the position cannot be given by the bank, the petitioners had written series of letters to the bank to refund the money along with the interest, which bank did not do. Then the writ petition was filed. In the writ petition Lordship, the judgment was passed and the bank was directed to pay the amount 1 crore 80 lakhs, 10 lakhs, 80 lakhs 10,000 Lordship within a period of 45 days, along with the interest of at the rate of prevailing bank lending rate of the bank Lordship. And if the amount is not paid within 45 days, then the rate of interest was given 18% per annum Lordship. That judgment your Lordship will find at page
15. It's 15. Annexure 1.
We have seen both the orders passed by the single, one of the learned single judge as well as the division bench.
No, first I would like to place before your Lordship the single judge.
We have read it. You just tell us the error apparent on the face of record for the purpose of review.
Then Lordship, against that order, writ appeal was preferred by the bank Lordship. In the writ appeal Lordship, your Lordship is pleased to peruse the first order page 20 Lordship. Page 20 Lordship. Relevant portion is page 22 Lordship, order dated 20th of July 22. Heard Mr. S. Datta, learned counsel, assisted by so and so. Issue notice only to for the limited purpose of considering 18% interest provided in the impugned judgment and the order. Notice is made returnable on appellant to take steps for service of the notices upon the respondents through register post. Mr. S. Datta, learned senior counsel, appearing for the appellant states that the principal amount of rupees so and so shall be refunded as per the impugned judgment and order forthwith. So, Lordship, the writ appeal was confined only for the consideration of the rate of interest as awarded by the Honorable Single Bench Lordship at the rate of 18%. Nothing more, Lordship. Their Lordship, after hearing, this order was not considered at all, Lordship. That division bench judgment, your Lordship will find at page 24. Page 24, Lordship.
Yes.
Mr. S. Datta, learned senior counsel, assisted by so and so. Counsel for a applicant bank and aspirant, learned counsel for the respondent, being aggrieved and dissatisfied by the judgment in order dated 21st to 22, passed by the learned single judge in WPC number so and so, the appellant bank has preferred this appeal only on the ground of award of interest on actual amount and further penal interest at the rate of 18%. The learned single judge, while disposing of the writ petition, directed the respondent bank to refund the amount in question, being rupees 1 crore 80 lakhs 10,000 along with the interest at the prevailing banking rate from 4/10/2016 within a period of 45 days from the date of the order. It was further directed that in case of the further delay from the period stipulated, the interest would be 18% per annum on the actual amount. The learned counsel at the bar are added that as per the order dated 20th/7/22 passed by this court, the appellant bank has paid rupees 1,80,10,000 back to the respondent. Mr. S. Datta, learned senior counsel appearing for the appellant bank, has submitted that the learned single judge has committed an error in granting interest at the prevailing bank rate and on failure 18% interest. It was submitted by Mr. Datta, learned senior counsel for the appellant bank, that as such the appellant bank was justified to deny the request of the respondent in the backdrop of the facts that the property in question is undemarcated till date. It was also contended that the award of interest is not sustainable, and further 18% interest on the actual amount is being imposed a penalty and delay in making payment. It was contended by Mr. Datta, learned senior counsel for the appellant, that even as per the RBI norms, the interest rate has been lowered, and in such view of the matter, it was unreasonable to impose 18% penal interest on the appellant, and he therefore submit that the appeal should be allowed. Per contrast, counsel for the respondent has opposed this appeal and has referred to section 34 of the CPT. It is the contention of Espirot, learned counsel for the respondent, that as provided under section 34 of the CPC, the interest can be awarded on monthly basis. Mr. Espirot, learned counsel for the respondent, further contended that the appellant bank, even though it is a public sector bank, kept a huge amount of rupees 1,80,10,000, 10,000, though the land was not even demarcated. Under circumstances, according to Mr. Roy, the huge amount was held up without any reasonable ground, and therefore the appellant bank is liable to pay penal interest on the principal amount which was not returned within a period of 45 days. Mr. Roy, learned counsel for the respondent, further contended that the interest awarded should be on monthly basis. On aforesaid ground, Espirot, learned counsel for the respondent, contended that the appeal being devoid of merit deserves to be dismissed. No further submissions, grounds, or contention has been raised by the learned counsel of the parties. Having heard the learned counsels for the parties, at the outset, it deserves to be noted that the principal amount of rupees 1,80,10,000 has been already received by the respondent. It is no doubt that the respondents are entitled to interest, as the huge amount of 1,80,10,000 was kept on the appellant bank since 4/10/2016. The record indicates that the appellant may be forced to get complete title of the land remarked for the purpose. However, the same could not be possible, and it is also the matter of fact that the property in question was subjected to the condition as it varies. However, as the appeal is only on the limited aspect of the award of the interest, we deem it fit not to further examine on the said question. The only question, this is important, Lordship, the only question which arises for consideration is whether the respondents are entitled to interest at the prevailing bank rate from 4/6/16 or not, and whether penal interest at the rate of 18% per annum as ordered by the learned single judge is sustainable. The contention raised by Mr. Roy that the respondent should be paid interest on monthly basis observed to be rejected in view of the peculiar facts and circumstances arising out of the appeal. More particularly, the fact that though the money was lying with the appellant bank, the fact remains that the land property in question was entangled with other discrepancy, including demarcation. In order to answer this question, even if a reference is made to section 34 of the CPC, the said provision also speaks of 6% interest, even if it is considered to be a commercial transaction as contended by Mr. Roy, learned counsel for the respondent. The same cannot exceed the contractual rate of interest. However, as there is no contractual rate of interest agreed upon, it should match the rate of interest of the nationalized bank in relation to the commercial transaction as provided under proviso of section 34(1) of the CPC. It is no doubt that the huge amount of rupees 1,80,10,000 was lying with the bank on 4/10/16. There is no contractual rate as per the transactions are concerned. Having considered the totality of the facts, we deem it fit to restrict the rate of interest to 6% from 4/10/16. We set aside the order of the learned single judge as far as it relates to the awarding of 18% interest per annum by way of penal interest. However, such interest shall be payable from 4/10/16 till the date of realization. The appellant shall pay interest amount so calculated directly to the respondent within a period of 2 weeks from today, as the respondents were paid back the amount of rupees 1,80,10,000. Later, the appellant is settled with a cost of rupees 25,000 to be paid to the respondent along with the interest. Accordingly, the appeal is disposed of. My humble submission in this lordship, when the appeal was admitted, lordship, when the notices were issued, the appeal was confined only for the consideration of rate of interest at the rate of 18%. And the prevailing bank rate interest, which was awarded by the Honorable Single Judge, was not the subject matter of the writ appeal, lordship. Already I have placed the said order, page 22 before your lordship, which says that page 22 or second para, issue notices only for the limited purpose of considering 18% interest provided in the impugned judgment and order. So this is one of the legality apparent on the face of the record, lordship, that subsequently while disposing the writ appeal, the prevailing rate of interest was also touched and the rate of interest was reduced to 6%. Lordship may be pleased to consider that if the petitioner would have invested in the fixed deposit, lordship, because after 6 years the amount was refunded. So this a fixed deposit investment, lordship, becomes double in 6 years. That amount would have been, lordship, 3.
That would be the interest.
No, not agreed. There is no question of agreed upon, my lordship, because I have purchased the land in the auction sale, lordship. It was the duty of the bank to hand over the position to me, which they failed. No, lordship, my humble prayer, the lordship, my submission is this, lordship, when the appeal was confined only for the consideration of the 18% interest, the single judge which awarded the interest at the rate of the prevailing banking rate, that was also considered, and the rate, interest was awarded only at the rate of simple interest, 6%, lordship. 6%, lordship. Apart from that, your lordship, me please that in 2016, the commercial lending rate was 14%. And your lordship, the petitioner number 2, he has paid the consideration amount by taking loan from the IDBI bank, paying interest at the rate of 10%, 10.90 person that your lordship will file in the additional affidavit filed by me. Your lordship may be pleased to take up the additional affidavit filed by me.
Yes. Yes.
Lordship may be pleased to come to page 29, para 3. Page 29 of the additional affidavit, para 3. Lordship got it? Para 3. I state that Dr. Bhabatosh Kumar Roy, who is the petitioner number 3 in the instant review petition, had availed a loan of rupees 50 lakhs from the IDBI Bank in order to purchase the land under e-auction sale notice published by the respondent number 2, the authorized officer, Punjab National Bank. And the said land was sanctioned by the IDBI Bank Limited to the petitioner number 3 at the interest of rate of 10.95 per annum, and Dr. Bhabatosh Roy, petitioner number 3, is currently paying EMI of 65,317 and toward the said loan of rupees 50 lakhs. By judgment and order dated, the Honorable Division Bench was pleased to set aside the order of the learned single judge relating to the award of the interest at the rate of 18% per annum, restricted the rate of interest to 6% per annum. So now your lordship may be pleased to come to page 32, lordship. 32, lordship. Here your lordship will see in the below the first para, loan amount shown 50 lakhs, your honor, interest rate 10.95% per annum. So lordship, I had paid 10.95% interest, lordship, to the IDBI, whereas the honorable division may reduce the rate to 6%, that too simple interest, lordship. And when the appeal was confined to the for consideration of the only 18% interest, lordship. So the first order passed by the Honorable Division Bench contradicted to the final judgment, lordship. And lordship, even as on today, lordship, if a loan is availed by any person, lordship, the rate of interest is above 12%, not below 12%, lordship. So, in the final judgment of the writ appeal, lordship, the Honorable Court has relied upon Section 34, but did not consider the explanation to Section 34. Lordship, may please to take up the Section 34. Section 34. Where insofar a degree is for the payment of the money, the court may, in the degree under order interest at such rate as the court deems reasonable to be paid on the principal sum adjust from the date of suit to the date of the decree, in addition to any interest adjusted on such principal sum for any period prior to the institution of the suit, with further interest at such rate not exceeding as per not exceeding not 6% per annum, and in the court deems reasonable on such principal sum from the date of the decree to the date of the payment, or to such earlier date as the court thinks fit, provided that where the liability in relation to the sum so adjusted had arising out of a commercial transaction, the rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate at which money are lent or advanced by the nationalized bank in relation to the commercial transaction. Then your lordship may we come to please to explanation 2, Roman 2. For the purpose of this section, a transaction is a commercial transaction if it is connected with the industry, trade or business or the party incurring the liability, lordship. So lordship, it was the land was put to auction. It was a contract. It was a lordship commercial transaction, commercial business. Bank does the business, lordship commercial business. So I was entitled to get at least the prevailing bank rate. And lordship, please to consider that when the bank failed to deliver the position to the petitioner, repeatedly the petitioner had written letter that he refund the amount. They used my money for 6 years, lordship. From 2016, money was refunded only in 2022, lordship. Huh?
6 years interest, they must have enjoyed the interest.
And they had my money was lent out to the other businessmen, lordship, and the bank has collected the interest at the rate of 14%, lordship. So even if, lordship, the prevailing rate of interest, that was not the subject matter of the writ appeal, lordship. So at least I may be given the prevailing rate of interest, lordship, at the relevant time. I am not praying for 18%, lordship. What was the rate of interest in 2016 prevailing commercial lending rate? I am entitled to get, lordship. Otherwise, great prejudice has been caused to me, lordship. How the bank has cheated the petitioner, lordship. They in the advertisement they stated that land is free from all encumbrances, this and that. And when the Mandal Kanungo Circle went for the search of, no land was found there. Points.
What is the date when you got your money?
Pardon, my lord.
What is the date when you got your money?
I received, lordship, the money, though the judgment, as per the judgment, I was entitled to get within 45 days, but they paid after 2 months, lordship, when I filed the contempt petition. Contempt petition was filed, then they only paid the amount, lordship. Contempt being contempt petition number, contempt petition number 332, lordship, and that was disposed on 15/5/23, lordship. More than a year.
Where is that?
Lordship,
Number, contempt number?
contempt number 332 of 22.
Disposed of on?
Pardon, Lord.
Disposed on?
Disposed of, lordship, as per my record, 15/5/23. 15/5/23.
Mr. Datta, you have a date of payment? No.
Lord, right now I don't have that.
Because the payment of the party performance. I can give the date of payment. I'm contacting my client. No, I have submitted. Pardon?
Are you relying on any judgments and orders?
No, Lordship, section 34 is very clear. There is no need of any judgment, Lordship, that in case of a commercial transaction, Lordship, business or trade, the rate of interest will be as per the commercial rate. Lordship. Explanation 2 of section 34 is clear.
Yes, Mr. Datta.
Well, the first of all, my lord, this honorable court at your wisdom, my lord, passed the order. That is, my lord, 6% interest, my lord, for the delayed payment. No, my lord, at any rate, it cannot be construed that there is an error apparent on the face of record. My lord, if it can be said to be an error apparent on the face of the record, my lord, if it is an error, it can be said as an error. My lord, the avenue of challenging the matter is somewhere else, not here. Then that is my first submission. Secondly, my lord, this is not a business transaction because, my lord, money could not be paid in time because there was a litigation on that, and the amount, it was mortgage property. And mortgage property could not be, my lord, demarcated by the mandal because the pleas were in, is not a clear, is a hilly track. Because of that, it is not the fault of the bank also. So therefore, there was some delay. Now, because of that, my lord, 18% interest is a too high. Because after all, if that rate is to be given, my lord, it is a public sufferance. Because ultimately, my lord, is a public exchequer will be, my lord, destroyed. Therefore, my lord, this honorable court, at your lordship's wisdom, very rightly passed an order that 6% interest should be given. Apart from that, because the delay, my lord, we had to pay 25,000 as cost, my lord. So therefore, there is no error apparent on the face of the record. And my learned friend want to equate the matter that the lending rate will have to be given. Is it the bank did not lend the money? You know, because of the delay, we could not pay. This honorable court has rightly said you have to pay some interest. And even if it is to be construed that it should be treated as a fixed deposit, well, even that rate also, that relevant time, it will be hardly 6.5 to 7%. So there is no error by this honorable court to passing this order. This will be my very short submission.
Lordship, if opportunity is given, I can produce the bank certificate by in the year 2016, the lending rate was 14%. Because I had contested during that period, your Lordship also may have the personal knowledge. JD Pharmaceuticals case, Lordship, where the rate of interest was 14%, Lordship. And Lordship, my submission of my learned friend, there is no error apparent on the face. While admitting issuing the notice in the writ petition, the division bench itself observed that this writ appeal will be confined only for the consideration of 18% interest and not to the prevailing lending rate of the bank, Lordship. So, but while disposing of the appeal, finally, Lordship, the rate of that was also wiped out, Lordship, and the rate of simple interest of 6% was given. As on today, Lordship, as on today also, let me complete. You have been, I did not disturb it.
No, I haven't.
I have not disturbed
concluded.
it.
When you say that the appeal is confined to 18% interest, what exactly do you mean? That the court is only required to decide whether 18 is to be granted or not granted? Is that what you're saying?
The simple meaning will be that, Lordship.
So if it is that, then we'd be happy to modify that order. That you're not entitled to 18%. End of story.
No, already that has been what I have submitted, Lordship. I do not demand 18%, but the prevailing rate of interest at that time.
No, you demanded because that's your prayer in the writ petition.
I am not pressing for 18%.
No, but the prayer in the writ petition was 18%. Therefore, the learned single judge granted 18%.
No. In the prayer portion, there was no prayer.
Yes. There we have seen. In your writ petition, prayer is for 18% of it.
Lordship, the Honorable Single Judge passed the order that the amount should be paid within 45 days. Failing which, if it is not paid within 45 days, the rate of interest will be 18%. That is the judgment of the Honorable Single Judge.
Right, but your prayer in the writ petition was also for 18%.
There might be, Lordship, but the court is to consider that it was a purely commercial transactions, Lordship, between the parties. Simple interest is given in an ordinary money suit, Lordship, not in commercial transactions, Lordship. And it is very clearly laid down in the orders, section 34, explanation Roman 2, Your Honor. How a retired colonel of the army,
What was the rate of lending rate of the National Bank at that point in time?
in 2014, Lordship, the lending rate was 14%, Lord. I can produce the bank certificate also. And one certificate I have already produced, where the lending rate by the IDBI bank.
What do you say, Mr. Doctor, with regard to proviso 34?
My lord, I will take your lordship to order 47. Your lordship is well aware, but still then, my lord, I want to satisfy your lordships whether the review lies.
Yes.
I'll read, my lord, order 47 1C, my lord.
Section?
Order 47.
Wonderful.
C, my lord, by a decision on a reference from a court of small causes, and who from the discovery of new an important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order on account of some mistake or error apparent on the face of the record, or for any of the sufficient reason desires to obtain a review of the decree passed. Now, whether it can be construed that it is an error apparent on the face of the record. In my respectful submission, it is not. My lord, if it is an error, my learned friend is required to go before the Honorable Supreme Court, my lord, by filing an SLP. My lord, if I may say so, another thing, my learned friend is trying to persuade your lordship by bringing a new fact that they obtained loan and the rate of 10.54 and all that.
9.5.
Now, whether all this material can be considered here. If it is said to be error, the judgment is suffered from some error, in that case only. And if it is some error, my lord, the avenue is somewhere else, so obviously your lordship will appreciate to that. In a review proceeding, I don't think it can be appreciated in that manner.
बोलो ना फाइल देख के बताइए.
Lord, your lordship will remember that 1980 Lord Krishna in a decision said, the review is something to asking for a moon. So therefore, it's a case really, I hope they could not persuade your lordship that in such type of cases review lies at all.
Lordship, the certificate issued by the IDBI bank from which petition number 3 has taken the loan. Lordship, if by taking loan from the bank, he has paid the consideration amount of the auction sale, Lordship. It is clearly mentioned in the additional affidavit, Lordship, and that document is not disputed, Lordship. Till date, no affidavit in opposition has been filed by the bank against my review petition. So the averments not controverted will be deemed to be admitted as per the Nasim Banu case 1993 Supreme Court. Why they have not filed the affidavit of mere submission will not do?
उनको बोलिए, मेरे को बोलिए.
SP Roy, Double Counsel for the petitioner, and Mr. Has the fellow senior counsel. Assisted Lance, even Shari, counsel for the Miss S. Musari, Land Counsel for the respondent. Submissions are complete, order reserved.
Obliged.
Obliged.
Take a short break and come back.
Item 3, for orders. Review petition 79/2023.
Yeah, please. Proxy, my lord, call for the record and record have been received, my lord. My lord, initially, my lord, the learned tribunal, my lord, pass order at page 69, where is, my lord, the husband and son, minor son and minor daughter and wife all declared foreigners, which is page 69. Thereafter, my lord, this review petition along with her husband approach this Honorable High Court by filing WPC number 3484, which is, my lord, at page 73. Regarding this review petitioner, my lord, court document exhibited in the court, in the tribunal, my lord, this voter list of her father of 1966 and one affidavit, because the father earlier used to write his title as Seal, Mahendra Kumar Seal. Subsequently, he write his title as Sarkar. And my lord, this affidavit also filed, and admit card of the review petitioner also exhibited, and one certificate from Gauhati. My lord, the name of the father is the same, only, my lord, this title, surname, earlier Seal and subsequently Sarkar. Father name is the same, my lord. Village is the same, my lord. And everything, my lord, Moja, Revenue Circle, everything is same. And that to effect, my lord, affidavit was filed. Admit card, my lord, and the voter list of 1966, being part of, my lord, public document. My lord, Honorable High Court earlier occasion, my lord, refer the matter to the tribunal to reconsider on the basis of observation made by the Honorable High Court. Second time, my lord, the tribunal told that this husband, Hitesh Biswas, and a son and daughter, three are Indian, but not consider the case of wife. It is the review petitioner. Earlier occasion, I could not see the LCR, my lord, while preparing the writ petition, my lord. Now, my lord, I have seen, my lord, seen the LCR, my lord, where I find it, my lord, there is no My lord, reference is in respect of this refute petitioner, Dipali Biswas, in the LCR. Only the reference in the name of the husband, that is the Khetis Biswas.
Yes, Mr. Sharma. Yes, sir. The reference against others.
Yes, Lordship. I also could not find the reference against Tripal Vista.
You can check the record.
Yes, Lordship. I have checked.
What is? The petition number one is answered. But that you never did anything for that. He changes surname.
You must try to depend.
यहाँ पे नहीं है वो कंपारिजन प्रमाण समझ obviously have a placement fund. यहाँ पे नहीं है अच्छा और करना इसको like पे रखा है कंपैरिजन था
Mr. Vice John and Council for the review petition. Also had so for the response. Next. This review application is directed against the order dated 26/11/2019 passed by this court in WPC 3484 of 2019. By the said order, the writ petition was dismissed without interfering with the opinion dated 27/8/2019, page 69, passed by Supreme. By which the alias, alias, and so there are 4 years.
There was no pending.
What is the sequence of the second opinion? Or why second opinion came?
Because my lord, remand of the case, my lord, second opinion is page 79. Because the case was remanded. Operative person, my lord, in my respect, my lord, page 82, paragraph 6.
Yeah, no. The number, yeah. It's. It's. So it is the. SA 69. The technical principle, Albert principle. Also, it may be stated that out of the petitioners in WPC 3484 of 2019, the opinion of the tribunal was not interfered with, that to the present petitioner, who was respondent number 2, insofar as the petitioner number 1, 3 and 4 of WPC 3484 of 2019 are concerned. By the order within 26/11/2019, they were directed to appear before the tribunal for further application. In this review application, the court is concerned with the present petitioner who was responding number 2 in WPC 3484 of 2019. Next. Amongst others, the learned counsel for the petitioner has submitted that during the proceedings of WPC 3484 of 2019, he could not, he did not produce the tribunal's records of FT, FT within bracket C 284 of 2015. However, on a perusal of the said records in connection with this review petition, it has come to his notice that the superintendent of police within bracket border bracket to Morigao had submitted reference only against the against the husband of petitioner number 2 of an namely Nitish PHRITIS, which passed. Accordingly, comment is that the tribunal would not have derived jurisdiction to proceed against the present petitioner.
Per contract, the learned standing counsel for the appeal border matters has proposed the there in this review application on the ground that this is not a new fact which has come to light, but these facts are already available when the petition was being heard. Next. On a perusal of the records of the tribunal, we have noticed that the inquiry was directed only against the husband of the petitioner, and it is in the form one and form two of the report of the inquiry officer, the name of the petitioner and the two minor children of the petitioner. Yes. Page 12 of the tribunal's reports, which is the reference to the erstwhile illegal migrants within bracket determination of this tribunal was exhibited in the proceedings as exhibit 4 within bracket 1. And then the four, the reference is found to have been made only against this was and not against the present petitioner. Next, it's well settled that the tribunals would get jurisdiction only on the basis of reference made for it. So therefore, the non-consideration of the setback accepted to be a good ground for entertaining this review application. This is the order dated 6/11/2019 passed by this court in WPC P484 of 2019. They were dismissing the said petition, the effect of the petition number 2. They're very all. There was no reference against the present petitioner. I'm sorry, petition number 2 in the WPC. P484 of 2019. I.e., the present petitioner. Same is if I recall. There's no reference against the present petitioner, namely, so and so. the impugn, the opinion dated 369, dated 7/3/2019, published by the in respect of the present petition in which also not is not found to be sustainable in the absence of any reports. Our comma report is further inclined to provide that this order cannot constitute the bar for the competent authority to make a fresh inquiry against the present petitioner. And if upon fresh inquiry from a petitioner is suspected to be not an Indian, from a competent authorities would be entitled to take such steps as they will be so. Next paragraph. The review petition stands allowed to the extent as indicated above. By interfering with the order dated so and so past into say 5484 of order dated 26/7/2019. 3484 of 2018. Next, that the records of the tribunal be sent back along with a copy of the order to be a part of record set that is bachelor. Next, that is standing order to be appeal border methods. They are also transmitted on what with this order, the Superintendent of Police border, Corridor. And to the common political, that it be in the order to the set of property. Next, the petitioner shall produce a copy of the order before the Superintendent of Police, the affected order to the government. Bring the order to the notice of the set of property. No orders. You will produce a certified copy of the order for this before the.
Item 4, review petition 27/2021 for hearing.
Need please, your lordship. The review petition is challenging the order dated lordship 9/11/2020 and the page numbers 13. Lordship. Relevant lordship paras in page 15, second paragraph, lordship.
Yes.
There are 3 documents by which the petitioner tried to show linkage with his father, lordship. One is periodic patta, that is in the name of her father, and one is will, and another one is GP certificate, lordship. Other than the other documents, lordship. The periodic patta was not considered. Page 15, lordship. As indicated above, the petitioner projected one Anwar Hussain, son of Palwan Sheikh as her father, which name appeared in the voter list of 1985, 1997, 2005, and 2008. at exhibits 8, 9, 10, and 11 of village Badaipara. In the voter list of 1952, 1955, and 1959, at exhibits 2, 3, and 4, it is projected to reflect the name of the petitioner's grandfather as Polanuddin Sheikh of village Piknapara. In the voter list of 1966 and 1970, at exhibit 6 and 7, the name of her projected grandfather is, however, differently reflected as Paloan at village 336 Badaipara. Exhibit 1 is the NRC of the year 1951 issued in the name of Palan Sheikh, projected grandfather of the petitioner. The periodic Kiras Patta at Exhibit 16 records the name of one Anar Ali. So this is the periodic Patta which is exhibited by the petitioner as Exhibit 12 Lordship of her father. Her father name is Anwar Hussain, but in the land record, his name recorded as Anar Ali Lordship.
Exhibit 12.
Yes, Lordship. Sorry, Lordship, Exhibit 16, Lordship. Periodic Kiras Patta, Exhibit 16, Lordship. So in the Exhibit 16, Lordship, the father's name, instead of Anwar Hussain, it was recorded as Anar Ali. So that document was not taken into consideration, saying that the said land document produced by the petitioner did not stand proof either through production of the original records or through the legal testimony of the custodian of the said document as per the provisions of law. My humble submission before your Lordship, periodic patta is a public document, Lordship. It need not to be proved by calling the public officials, Lordship. This is a document prepared by the public officials and these are public documents, Lordship. Thereafter, Lordship, Exhibit 13 and 14 are the voter list of 2010 and 16 enlisting the name of the petitioner Monwara Khatun, wife of Samsul Haq, as a voter of village Jharpara Part 1. The said voter list cannot be seen to support establishment of linkage inasmuch as the relationship of the petitioner has been shown with her husband and not with the projected father. Moreover, no voter list or any land document which are admissible in law were produced and exhibited reflecting the name of the petitioner by showing relationship with her projected father or grandfather. Here, Lordship, the father of the OP adduced his evidence as DW2, Lordship. And DW2, while preparation of the evidence in chief, produced one document, that is Exhibit A and Exhibit B, Lordship. Exhibit A is in the original writ petition, Lordship, page 56. Exhibit A is the Jamabandi copy showing the name of the DW2 in the Jamabandi, Lordship. His evidence in chief was annexed as page number 56 of writ petition, Lordship. 53 it started and relevant portion is paragraph 10, page 56, Lordship. This is evidence in chief of DW2 Anwar Hussain. Paragraph 10 is mentioned that I beg to state that the grandfather of the opposite party, that is my father, died in the year 1974, that I have a Jamabandi copy of land measuring 0 biga 3 katha 0 lesa covered by patta number 151 at Revenue Village Badaipara Circle Srijangam under North Salmara subdivision in the district of Bongaigaon. Paragraph 10, Lordship. Yes, Lordship. Bongaigaon, Assam, as Anar Ali, that I beg to state that my actual and correct name is Anwar Hussain, but in my Jamabandi copy, my name has been recorded as Anar Ali instead of Anwar Hussain, that Anar Ali and Anwar Hussain are same and one single person. So Exhibit A is the Jamabandi copy, and in paragraph 11, he enclosed his voter ID, Lordship. That I beg to state that the Election Commission of India issued a voter ID card in my name having voter ID card number so-and-so at village Bhadaipara under Abhayapuri police station in the district of Bongaigaon, Assam. Exhibit B is the said voter ID. So father himself adduced evidence enclosing these two documents, but in the impugned judgment, it was reflected that there was no other documents. I'm again reading this line. Moreover, no voter list or any land documents which are admissible in law were produced and exhibited reflecting the name of the petitioner by showing relationship with her projected father or grandfather. Exhibit 15, which is the electro photo identity card issued in the name of the petitioner, is not a relevant piece of document to prove citizenship in law. The Gaon Panchayat certificate dated 25/1/2017 at Exhibit 12 issued in the name of the petitioner and which was brought on record to serve as a linked document to the projected father, Anwar Hussain, rendered itself and as inadmissible in evidence inasmuch as the said certificate and the contents thereof did not stand proof through the legal testimony of the author issuing authority. So GP certificate was not proved by the petitioner, Lordship. Noticeably, though, in the voter list of 1985, 97, 2005, and 2008, at Exhibit 8, 9, 10, and 11, the name of the
So in the writ petition, have you specifically pleaded that these two exhibits are not considered? Because we are missing it. Your
Lordship,
writ petition.
Lordship,
in your
these are
writ petition-
these are the documents adduced by the father, Lordship.
No,
In
we
his
understand, but in the writ petition, this ground was not taken that in the opinion, these two exhibits are not considered.
Lordship, that was the opinion given by this court, not by the tribunal, Lordship. Tribunal held that there are discrepancies in the name and age of the,
No, in the tribunal also, these two documents are not referred to in the opinion.
Lordship.
But in the writ petition, you did not urge that. If you don't urge, we won't go into that.
Lordship, but look, that findings is there that there was no
It will be there-
land
there-
document,
if
there
you
was
don't
no
point
land
it out,
document.
We are going by the opinion. In the opinion, there is no reference to that.
Lordship. But Lordship, already those were exhibited by the DW2 before the learned
Let's
tribunal.
point out before us. What is the requirement of going to the LCR and then finding it out? I do it out of the way,
Lordship.
but.
And
if you-
another thing,
If you
Lordship,
don't assist us in reading the trial court records, you don't expect us to go through each and every document and then find out what has happened to that.
but Lordship, one more thing, the will which was exhibited by the petitioner, Lordship, which was executed by her father, that was also not taken into consideration on the ground that there was no probate.
Correct.
But as per 2013 Lordship Succession Act, in Mohammedan law, probate is not required, Lordship.
But then who will prove this as signature? Because then you will have to also establish that that Hiba was done in accordance with the will. And there was,
Father-
at the property
Lordship.
was in fact parted away. That
Lordship.
evidence is not there.
Father himself adduced evidence,
But
Lordship.
the parting of the property evidence is not there. You see, to consider a gift under the Mohammedan law, what are the
Lordship.
requirements?
The acceptance.
We'll continue on this 19th of March.
Lordship, can it be possible after 21st March, Lordship?
Twenty-sixth. It's possible, I will not be taken off the date. List again on. 36, 26. You just examine the record for that.
Lord.
That is something we missed in the repetition. Just look into it. Because some it not. In course of submissions from our assistant. From the common learning council for the petitioner had referred to exhibit A and exhibit B, which were exhibited by Anwar Said,
Yes, Lordship. Father of the.
projected father of the petitioner as the petitioner. Who's father? A reference to the non-consideration of the said two exhibits by the learned tribunal. Apparently not treated in the written petition. Who's father? This is in context of the submissions made by the learned counsel to the petitioner that this court had arrived at the finding that no documents were exhibited, no further documents were exhibited to show that the father of the petitioner was known by another name of
Anar Ali, Lordship.
Anar Ali. Just examine his records before next date.
Can I retain those?
Okay, we have the list once went through. The on the prayer made by Mr. G. Sharma, and it's the MP bottom address. Records of the travel be handed over to him for perusal and to address the court of the next date of the thing. Travel record. This will be the order.
Lordship, indulgence, I have an urgent requisition slip for an IA at filed on 11th of February, which ought to have come with item number 1 and 2, my lord. Also, my wakalatnama, which I find does not reflect my name. So when I checked yesterday, the let us, my lord, just give it a try to keep, because it will help my friend also in the assistance to my arguments to my lordship. My friend also, it will be of some help. Since both of us were missing our original writ petitions. my
No,
lord.
we don't know about that, but listing is a bit difficult right now.
If I may be allowed to requisition it, my lord,
It has to
Yes.
be some other day, not today. It will not come. Production list can't be
Then-
prepared right now.
then would it be proper then for me to file a mention memo? And my lordship can fix it for Monday or something? I'm okay,
You may give the mention memo, that's no issue, but it has to come by way of a listing.
my lord. And it will come with the main writ petition and the 1 and 2.
We'll pass orders here. Which item?
Item 1 and 2, my lord.
Item 1 and 2.
Writ petition is, my lord,
You so that
4369.
both sides are represented. On the appearance made by Mr. P. N. Chaudhary, learned counsel for the petitioner, the matter stands adjourned as he has submitted that an interlocutory application has been filed in the matter. Next, list on.
Monday, my lord, if it's convenient to my lord. Deeply obliged.
Yes. Just wait.
No, my lord, same matter. I'm also the other side.
Possible for the day of.
10 is 2019 matter.
Some developments are going on, my lord. I have been instructed. I am for the petition.
Okay, you are appearing for?
Bank, respondent.
I am for the
Respondent
petition.
bank. In the joint prayer made by learned counsel for the petitioner as well as the respondent numbers 1 to 3. The matter stands adjourned today. List on, give this date after 2 weeks. Yes. We'll give the date.
Date.
We'll in the meantime.
Deeply obliged.
Please, Lordship. Lordship, recommended item number 12, Lordship.
12 is review petition. Please wait till the matter is called.
Lordship, the case record of the petitioner that has not been received, Lordship. Case record of the petitioner that has not been received. The record which are available, Lordship, that belongs to Safayat Ali, the uncle of the petitioner, Lordship.
That also we'll have to look into it and then file for this.
May I please, Lordship? Lordship, beg to pray for listing of a new matter, Lordship, by tomorrow, Lordship, as
Listing, give it to the
petitioner.
court master. Listing, please give it to the court master.
May I please, Lordship? Lordship, in respect to item 13, Lordship, I am praying for Lordship upgradation if time permits, Lordship.
13.
13(1)(3), Lordship. Lordship. Deeply obliged.
Daily list, item 3 for admission.
More.
Item number 4.
Yes.
Deponent Lordship, he has transferred from the school police station. It's, yes. Because you want to start first. The 15 days may be.
He's been shifted from Eastwood police station.
Yes, Lordship.
Within how much time?
It's 2 days. On the coming week, Lordship. In the coming week, Lordship, next week, Lordship.
Concern from the government counsel for the petitioner, Mr. N. Kalita, when it's coming applicant, praise for an adjournment. Here is allowed. List again on 6/3/2028. 6.
That's all. Lordship.
Item 3.
And pहले pass over the matter, just for timing, Mr. P. K. Rochester, मैं लेकिन another court matter.
Supplementary item 14, part 3rd.
Lords, in this matter, the petitioner had argued that there were defects in the inspection report and there were defects in the provisional assessment, due to which he had filed a writ petition. Our contention before the learned single judge was that this was a theft case of theft of electricity, which also amounts to unauthorized use of electricity. Therefore, a provisional assessment made under section 126, there's an alternative remedy under section 127 in view of the judgment laid down by the apex court in Orion methods.
and then followed by a single bench and a division bench of our High Court, and subsequently in several judgments. The contention of the petitioner before your lordship was, of the appellant before your lordship was, that the judgment in Orion Metals is sub silentio and per inquiry, because it does not take into account the earlier judgment rendered by a 3-judge bench in the South Core judgment, the Southern Odisha Electricity Company judgment, and because it does not take into account the Electricity Removal of Difficulties Order 2005. So before addressing your lordship on that issue, my submission on that aspect would be a judgment, your lordship. A judgment, your lordship, a ratio of a judgment is only binding in the background of the facts in which it is rendered, your lordship. In Southern Electricity or Southern Odisha Electricity Company judgment, which is called the South Core judgment, the fact was that the appellants, the petitioners before the Supreme Court in those matters, your lordship, they had abstracted electricity more than what they were authorized to abstract under the terms of supply under which they are getting their connection. So it was just a simple case of unauthorized use of electricity simpliciter. If I may take your lordship to section 126 of the Electricity Act. Because if we read the judgment in the background of the facts in which it was rendered, perhaps the issue of per inquiry may not arise. If your lordship has the explanation to section 126, explanation B, explanation B to section 126, in in the South Core judgment, the facts before the Honorable Apex Court was that the consumers in that case had extracted more electricity than they were supposed to consume. That is covered by section explanation B2, by means not authorized by the concerned person or authority or license. And in those circumstances, and in in that series of judgments, your lordship, it was, since the Honorable Apex Court was only dealing with unauthorized use of electricity simpliciter, it discussed the legal background and talked about cases under both 126 and 135. There is one particular statement, your lordship, which is somewhat relevant. Paragraph number 49 of the judgment. In that background, while discussing such cases of 126 simpliciter, it is the name of the judgment was Executive Engineer, Southern Electricity Supply Company of Odisha Limited, Southco, versus Sri Sitaram Rice Mill. Yes. If your lordship has the facts, your lordship, they start at paragraph number 5. They'll substantiate my submission that it was only a case of unauthorized use of electricity simpliciter without any allegation of theft. They started paragraph number 5. We may briefly refer to the facts giving rise to the present appeal. The respondent herein, a partnership firm, claims to be a small-scale industrial unit engaged in the production of rice. For carrying on the said business, it had obtained electricity supply under the agreement. Between the present appellant number 1 and the respondent, the agreement dated so-and-so was executed for supply of power to the respondent. Keeping in view the contracted load, the respondent was classified as medium industry category. This category deals with contract demand of 99 kV and above but below 110 kV. According to the respondent, since the day of connection to the power supply, the meter and all associated equipments have been inspected by the appellants. On 10/6/2009, the Executive Engineer Jaipur Electrical Division and Subdivisional Engineer Electrical MRT Division Jaipur inspected the business premises of the respondent's unit and dump was conducted. These officers issued a dump report by noticing as follows: dump of the meter taken, calibration of meter done, and error found within limit. If any abnormality detected in dump, it will be intimated later on. It is the case of the respondent that no intimation was given to it as to the finding of any defects, if any, in dump. On 25/7/2009, a provisional assessment order bearing number so-and-so was issued by the appellant to the respondent. Intimation bearing number 853 has also been issued on the same day, which informed the respondent that there was unauthorized use of electricity falling squarely within the ambit of provisions of section 126. In the dump report dated 10/6/2009, it was stated that there was unauthorized use of electricity, and this is important, Your Lordship, and the maximum demand hereafter MD had been consumed up to 142 kVA. So that is the allegation and the facts in which this judgment was rendered. Be that as it may, in paragraph number 49, if I may quickly take Your Lordship to paragraph number 49. While discussing the interface between 126 and 135, paragraph number 49. Once the court decides that it has to take a purposive construction as opposed to textual construction, then the legislative purpose sought to be achieved by such an interpretation has to be kept in mind. We have already indicated that keeping in view the legislative scheme and the provisions of the 2003 Act, it will be appropriate to adopt the approach of purposive construction on the facts of the case. We have also indicated above that the provisions of section 126 of the 2003 Act are intended to cover the cases over and above the cases which would be specifically covered under the provisions of section 135 of the 2003 Act. Now, this is what the apex court has held. That the cases under section 126, they may cover cases over and above section 135, because only if there is a dishonest intention prima facie, only then is 135 attractive. Now, for a judgment to be per incurium, Your Lordship, 3 tests have to be met. Firstly, that it has to be in ignorance of a binding legal precedent or in ignorance of a settled position of law. And the ignorance of either the binding precedent or the settled position of law should give rise to a ratio which is irreconcilable with the existing settled position. Now, for that, Your Lordship, I am just placing one judgment. This is the judgment in 2024 SCC 1, Dr. Shah Faisal versus Union of India. I am relying on paragraphs 25, 26, 27, and 28. So paragraph 28, Your Lordship, the principles of per incurium have been summarized. There the apex court was determining the validity of the presidential order under Article 370. So while discussing the aspect of per incurium, paragraph, I'll start from paragraph number 27 at page number 13. Having discussed the aspect of doctrine of precedent, we need to consider another ground on which the reference is sought. That is the relevance of non-consideration of the earlier decision of a coordinate bench. In the case in hand, one of the main submissions adopted by those who are seeking reference is that the case of Sampath Prakash did not consider the earlier ruling in Premnath call. The rule of per incuriam has been developed as an exception to the doctrine of judicial precedent. Literally, it means a judgment passed in ignorance of a relevant statute or any other binding authority. The aforesaid rule is well elucidated in the Halsbury's Laws of England in the following manner. The court is not bound to follow a decision of its own if given per incuriam. A decision is given per incuriam, one, when the court has acted in ignorance of a previous decision of its own or of a court of a coordinate jurisdiction which covered the case before it, or when it has acted in ignorance of a decision of the House of Lords. In the former case, it must decide which decision to follow. In the latter, it is bound by the decision of the House of Lords. So in the present case, the judgment in Orion Metals would be per incuriam if it is in ignorance of any provision of the Electricity Act, and number two, if it has failed to acknowledge the existing decision of in Sitara Bryce. So if I may take your lordship to the judgment, quickly to the judgment in Orion, your lordship.
Really confused. Excessive also.
Orion Metals, your lordship. I'll read from paragraph number 3. I'll just briefly take your lordship to the facts. That would also have some bearing on this issue. Facts in Orion Metals. From paragraph number 5.1. Yes, the facts started paragraph number 2.2, your lordship. During the page number 591. During the inspection, it was noticed by the inspecting team that the input current is abnormally high from output current at TTB end in respect of RNB phase of PT second wires. The inspecting team on breaking open the TTB has also found some foreign materials inside. In view of such discrepancies found during the inspection, the inspecting team was of the view that there was energy theft. There was a theft of energy by tampering of the meter by the respondent company. So in these facts, your lordship, a provisional assessment was done. I'll read paragraph number 2.5. Aggrieved by the provisional assessment and the consequential demand, the respondents have filed writ petition in WP number so and so before the High Court, questioning the jurisdiction of the assessing officer in issuing the provisional assessment and the consequential demand for a sum of rupees so and so. In the writ petition, one of the grounds was that the assessing officer who prepared the provisional assessment, not being a party to the inspection team, had no authority to make the provisional assessment under section 126(1) of the Act. In the writ petition, it was also alleged that the provisional assessment was not in accordance with section 126 of the Act, and as such assessment cannot be given effect to. In these facts, your lordship, the findings of the apex court are at paragraph number 13. They start at paragraph number 13. It is clear from a reading of section 126(b)(3) of the Act that instances of use of energy to a tampered meter is included in the definition of unauthorized use of electricity. If that is so, there is no reason for excluding the power of the authorities for making assessment under section 126(1) of the Act to assess the loss of energy where electricity is used through a tampered meter. This is important, your lordship. All instances of unauthorized use of energy may not amount to theft of electricity within the meaning of section 135 of the Act, but at the same time, the theft of electricity which is covered by section 135 of the Act will fall within the definition of unauthorized use of electricity. Then, Your Lordship, should I continue, Your Lordship? Yes, very well. As per section 135 1A of the Act, without prejudice to the other provisions of the Act, the licensee or supplier, as the case may be, upon detection of theft of electricity, is empowered to disconnect the power supply immediately. Further, as per the third proviso to section 135 1A of the Act, the licensee or the supplier, as the case may be, on deposit or payment of assessed amount of electricity charges, without prejudice to the obligation to lodge a complaint, can restore the power supply electricity within 48 hours of deposit stroke payment of such amount. Thus, it is clear that the authorities under the Act are empowered to make a provisional and final assessment by invoking powers under section 126(1) of the Act, even in cases where electricity is unauthorizedly used by way of theft. When a consumer deposits the assessed amount, the licensee or the supplier has to restore the power supply. The assessed amount referred to in aforesaid proviso relates to the assessment which is contemplated under section 126(1) of the Act only. There is an apparent distinction between section 126 and section 135 of the Act. Section 126 forms part of the scheme which authorizes electricity supplier to ascertain loss in terms of revenue caused to by the consumer by his act of unauthorized use of electricity, whereas section 135 deals with the offense of theft if he is found to have indulged himself in the acts mentioned in clauses A to E of subsection 1 of section 135 of the Electricity Act. Further, it is also clear from section 154 of the Act, which prescribes procedure and power of the special court, that the special court is empowered to convict the consumer and impose a sentence of imprisonment. The special court, in cases where a criminal complaint is lodged, is also empowered to determine civil liability under section 154(5) of the Act. As per section 154(6) of the Act, in case civil liability so determined by the special court is less than the amount deposited by the consumer or the person, the excess amount so deposited by the consumer or the person shall be refunded by the licensee or the person concerned, as the case may be. Merely because the special court is empowered to determine civil liability under section 154(5) of the Act, in cases where a complaint is lodged, it cannot be said that there is no power conferred on authorities to make provisional assessment or final assessment under section 126 of the Act. So basically what it means, Your Lordship, is that suppose today X person tampers with the meter. That is an act of theft of electricity, for which his criminal prosecution will be under as per the procedure laid down in section 135 and the succeeding sections. But to make good the loss which the company has suffered because he has stolen electricity, that will be assessed as per the procedure laid down under section 126. Now, if you're if I may take your Lordship to paragraph number 14, there, while dealing with a case of theft of electricity, the earlier judgment in Southco was specifically referred to. I'll just read, Your Lordship. In Southern Electricity Supply Company of Orissa versus Sitaram Rice Mill.
A strong point has been made with regard to the previous inspection and the
Yes,
theft.
that is precisely why, Lordship, the aspect of the previous inspection. These are factual issues. They should be placed before the appellate authority. We will also get a chance to respond on facts, Your Lordship, and the authority has the technical expertise to decide that issue. In Southern Electricity Supply Company of Orissa Limited versus Sitaram Rice Mill, this court has considered the scope of the explanation to section 126(b)(4) of the 2003 Act. I am reading from paragraph 14. In the aforesaid case, as there was no allegation of theft, this court has held consumption in cases of sanctioned stroke contracted load comes within the meaning of unauthorized use of electricity as per explanation B4 of section 126 of the Act, Electricity Act 2003. Drawing a distinction between section 126 to that of section 135 of the Act, paras 29 and 61 of the aforesaid judgment read as under. That I have already taken your Lordship through. So it is not that the bench, while dealing with Orion Metals, was ignorant of the law laid down in Sitaram Rice Mill. While being cognizant, they said that these powers can exist parallelly with each other. And if I may continue to paragraph number 15, Your Lordship. We also do not find any valid reason for making a distinction as made by the High Court in applying section 126 of the Act. From the scheme of the Act, it appears that after inspection team notices unauthorized use of energy by tampering the meter, the authorities can disconnect the power supply immediately and make immediate assessment for loss of energy by invoking power under section 126(1) of the Act. The term unauthorized use of energy is a wide connotation. There may be cases of unauthorized use of energy not amounting to theft, which are cases which exceeding the sanctioned load or using the electricity in the premises where its use is not authorized. But at the same time, when there is an allegation of unauthorized use of energy by tampering the meter, such cases of unauthorized use of energy include theft as defined under section 135 of the Act. The power conferred on authorities for making assessment under section 126(1) of the Act and the power to determine civil liability under section 154(5) cannot be said to be parallel to each other. In this regard, we are of the view that High Court has committed an error in recording a finding that both proceedings cannot operate parallel. So, my lord, in the impugned judgment, which is before your lordship, what the honorable single judge has finally disposed of the matter by directing the appellants before your lordship to approach the appellate authority, where all factual issues, including the previous inspection made 3 days before, that can be examined by a technically qualified authority, your lordship. And this judgment, your lordship, in my humble opinion, has been rightfully followed by the several single benches, as well as by the division bench in the Shivelois matter, your lordship. Now, coming to the aspect of whether your lordship had indicated that whether a high court can say that the judgment passed by the apex court is per inquiry, your lordship. There are two judgments. Otherwise, lordship, perhaps is I'm just placing the judgments. I'll just one is the issue. Yashod.
There is one judgment on record by one high court declaring the judgment of a constitutional bench not to be followed. The opinion of the one constitutional bench was followed by another constitutional bench, and still the high court says that it was not a correct law.
I mean, even this, your lordship, what the apex court has held, I mean, the powers of the high court under 226.
Supreme Court has after that, the Supreme Court has never made any remark against the high court.
First, if I may take your lordship to the judgment in. ಸುರೇಶ್ ಕುಮಾರ್ ಬಿಟ್ಟ ಯಶೋಧ ಬಾಯಿ ಬಿಟ್ಟ ಬಟ್ কোনটো কমন এইটো বেছিকে আহিছে ন I'm referring to paragraph number 9, you know. Yes. Uh, My lord, in the first judgment is the judgment in South Central Railway Employees Cooperative Credit Society versus B. Yashodabai. Perhaps this was the judgment which your lordship was referring to. Yes. This is in this judgment, the relevant paragraphs are paragraph number 14 and 15. Yes, yes, your lordship. This is precisely on this issue, your lordship. May I read your lordship? Yes, very. Fourteen and 15, your lordship. We are of the view that it is not open to the High Court to hold that the judgment delivered by this court, that is the Supreme Court, in South Central Railway Employees Cooperative Credit Society Employees Union versus Registrar of Cooperative Societies was per incuriam. If the view taken by the High Court is accepted, in our opinion, there will be total chaos in this country. I'm reading from paragraph number 14 now, because in that case, there will be no finality to any order passed by this court. When a higher court has rendered a particular decision, the said decision must be followed by a subordinate or a lower court, unless it is distinguished or overruled or set aside. The High Court has considered several provisions, which in its opinion had not been considered or argued before this court when CA number so-and-so was decided. If the litigants or lawyers are permitted to argue that something what was correct but was not argued earlier before the higher court, and on that ground, if the courts below are permitted to take a different view in a matter, possibly the entire law in relation to the precedence and ratio decidendi will have to be rewritten, and in our opinion, that cannot be done. Moreover, by not following the law laid down by this court, the High Court or the subordinate courts would also be violating the provisions of Article 141 of the Constitution of India. The other judgment which I was carrying, your lordship, Sugandhi Suresh Kumar, there in paragraph number 9, the same thing has been said in different words, your lordship. This is 2002 to SCC 420 at paragraph number 9. It is impermissible. It is impermissible for the High Court. Paragraph number 9, your lordship. Sugandhi Suresh Kumar versus Jagdishan. It is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Supreme Court laid down the legal position without considering any other point. It is not only a matter of discipline for the High Courts in India, it is the mandate of the Constitution as provided in Article 141 that the law declared by the Supreme Court shall be binding on all courts within the territory of India. It is pointed out by this court in Anil Kumar Neotia versus Union of India that the High Court cannot question the correctness of the decision of the Supreme Court, even though the point sought before the High Court was not considered by the Supreme Court. My lord, here I'll just digress for a while. I may be permitted to digress. A point was raised, your lordship. Firstly, your lordship, another judgment was referred to by the appellants. This is Kerala State Electricity Board versus Thomas Joseph. There too, your lordship, the facts are that the respondents who were commercial industrial consumers having low tension connections, they were abstracting electricity beyond their connected load, your lordship. So it's similar to what happened in Sitaram Rice Mill. That was not a case which deals with theft of electricity simpliciter, your lordship. So another argument which was made, your lordship, the judgment was placed before lordship. This was judgment by Justice Pardiwala. The citation is 2023-11 SCC 700. Kerala State Electricity Board versus Thomas Joseph. Was it was relied upon by my learned friend in the last occasion. The facts, your lordship, are summarized in paragraph number 6. Kerala State Electricity Board versus Thomas Joseph. This is 2023 11 SC 700. By learned friend, yes. Paragraph number 6, your lordship, the facts are summarized. So, in the present litigation, paragraph number 6, your lordship. Yes. In the present litigation, all the respondents are commercial stroke industrial consumers having low tension connections. It is not in dispute that at the time of inspection undertaken by the officials of the appellant board, all the consumers were found to be drawing electricity in excess of the connected stroke contracted load. The issue that arises is whether the respondents can be assessed at the rate equal to twice the tariff applicable as stipulated in section 126(6) of the 2003 Act. So it is in these facts, your lordship, that there was only reference to Sitaram Rice Mill and not to Orion Metals, Your Lordship. Because that was only a case of excess drawal of electricity beyond their contracted load. So my first submission would be, Your Lordship, that the judgment in my first submission would be, Your Lordship, it is the judgment in Orion Metals, which will govern, at least govern the, cover the case of the petitioner, because that is the judgment which deals with cases of theft of electricity. Besides that, Your Lordship, there is no irreconcilable difference in the ratio of the judgments laid down in Sitaram Rice Mill and then followed in Kerala State Electricity Board with that in Orion Metals. In fact, Sitaram Rice Mill was referred to and taken note of by the bench in Orion Metals while rendering the judgment there, Your Lordship. And therefore, it has been correctly followed by coordinate benches and in the single judge in the judgment before Your Lordship in appeal in the present case. Another argument was raised, Your Lordship. I'll just address it. That the electricity removal of difficulties order 2005, which is at page number 25 of the compendium handed over, that was not taken note of by the Honorable Apex Court, Your Lordship. I'm just addressing that argument. It will perhaps not have any bearing on the ratio in the judgment, because what this electricity removal of difficulties order 2005 in Orion Metals, yes, my learned friend had one of his arguments was that this electricity removal of difficulties order 2005 was not taken note of. I'm just addressing that argument. That this, what this removal of difficulties order in essence provides for is that if we take the provision dealing to terms and conditions of supply contained in the Principal Act, regulations covering assessment of charges for theft of electricity is not there in that provision. So what this in essence does is empower state commissions to include such provisions in the supply codes that they draft individually to cover their states. So in exercise of the powers conferred by this electricity removal of difficulties order, read with the Electricity Act, the Supply Code of 2017 and the earlier supply codes also were enacted, Your Lordship. If I may quickly take Your Lordship to page number 27 of the compendium, it says that it will cover cases of theft of electricity, which is completely in tune with the electricity removal of difficulties order. I'm reading clause 1.3.1 coverage. This code inter alia covers C, matters related to theft and unauthorized use of energy. So once that power has been exercised, Your Lordship, in this, the removal of difficulties order, Your Lordship will have at page number 25. Then the supply code begins at page number 26. Supply code begins at page number 26. And the clause I was referring to, Your Lordship, is at page number 27, 1.3.1 coverage. This code inter alia covers C, matters related to theft and unauthorized use of energy. So once this supply code, my learned friend has already taken Your Lordship to the relevant provisions of assessment of electricity in cases of theft of electricity, which Your Lordship will find at page number 48. Since the same procedure is otherwise given, Your Lordship, I'm referring to clause number 7.5.4 at page number 48. The method of assessment of electricity charges payable in case of theft of electricity, pending adjudication by the appropriate court, shall be the same as in the case of provisional assessment for unauthorized use of energy specified under clause 7.4.2. So since the same procedure is given, these provisions are in tune with the ratio laid down in Orion Metals. Because in Orion Metals says that the authorities are empowered to undertake a provisional assessment. Therefore, in tune with that ratio, the same procedure has been adopted. So even if this had been taken note of, Your Lordship, materially there would not have been any change in the ratio, because this is what the Honorable Apex Court has also held. Because the language used in the removal of difficulties order is the electricity supply code as specified by the State Commission under section 50 shall also include the following, namely method of assessment of electricity charges payable in cases of theft of electricity pending adjudication by the appropriate court. So firstly, it says that there are two methods of adjudication. One is the final adjudication by the special court and the preliminary assessment under 126. What this removal of difficulties order, a careful reading of this order will show is that it does not postulate, Your Lordship, that a separate procedure has to be laid down. So this is also in tune with the judgment of in Orion Metals. The procedure can be one and the same. It says that there should be some procedure, but it does not say that there should be a separate procedure for 126 and 135. And then another argument, lastly, Your Lordship. So my submission is that, firstly, even if this had been taken note of, the end ratio would have been the same in Orion Metals. And my last submission, Your Lordship, is that the petitioners had referred to in the compendium at page number 60, they have referred to a circular of 11/5/2021. This is a circular, unfortunately, issued by us, Your Lordship, where it is said that in cases of theft of electricity, there will not be any appeal. Your Lordship, this circular is completely in the teeth of the judgment laid down in Orion Metals. And since this honorable court has clarified the position in Shiv Alloys and then upheld by the division bench, I say it with all the responsibility at my command that this circular has not been given effect. All cases of theft of electricity where there has been any provisional assessment under 126 or final assessment, appeals are being filed and decided under section 127. My Lord? My Lord, I'll advise them, but we are not giving effect to it because now, anyways, the law laid down by the coordinate bench and the apex court holds the field. Anyways, the circular, Your Lordship, cannot override that. I'll advise them to withdraw it immediately. But since then, Your Lordship, no case, Your Lordship, has been denied an appeal because it is a case of theft of electricity simplicity. My Lord. It's a circular dated 18/5/2021. It is at page number 60 of the compendium. And the offending provision, Your Lordship, of that notification is at page number 65. Appeal to appellate authority, there is a portion in bold, says that however, if a person is booked under section 135 of the Electricity Act 2003, there is no provision of appeal before the appellate authority. This, Your Lordship, is not the legal position, Your Lordship, correct legal position. So that is my submission, Your Lordship. Perhaps the issue of per incurium may not have to be gone into, Your Lordship, because the judgment in Orion Metals, Your Lordship, covers all these aspects argued by my learned friend. It starts at page number 60, the circular, 18/5/2021, 60. And the relevant provision is at page, paragraph number E, clause E at page number 65. So in conclusion, Your Lordship, my submission is that there is no infirmity in the order passed by the Honorable Single Judge, though some factual issues have been raised by the appellant, Your Lordship, which have to be gone into. The Honorable Single Judge has rightfully and correctly referred them to the appellate authority, which is a technical body created, statutory technical body created under the provisions of section 127. And there the appellant, the petitioner will be at liberty to raise these issues and we'll also respond, Your Lordship.
It is present, the data submissions. Mr. KP Pathak, learner, any question for the petition is concluded. Order is out.
Deeply obliged. My lords, I have prepared a short synopsis of my argument. May I be permitted to place them?
Submits written note of submission.
Deeply obliged. All right.
Time being item 3 for admission.
Your Lordship, my lord, I'm sorry that I was not able to come. My lord, before my friend submits some report, if your Lordship permits me to rephrase the facts again before your Lordship. My lord, I take your Lordship to the impugn order that has been challenged in this writ petition. We have challenged the order dated 18/12/2025. Page 20. 18/12/2025. Page 43. That was rejected by the Foreigners Tribunal, Nalbari 1, regarding my bail. Dated 18/12/2025. My lord, then I take your Lordship, why I am inside the jail, that is at page 36. That is dated 6/2/2025, page 36. In exercise of power under 3(2)E of Foreigners Act, restricting the movement of such and such national government hereby that he shall reside in special camp and located in district collector Tiruchirappalli in the event of release from prison till cooperation. This order, along with my passports, I was allowed to go on bail by order dated, my lord, page 28, dated 13/2/2025. After 6/2/2025, 13 to page 28. Your lordship may look into paragraph 4, last line, page 30. That 3(2)E notice was taken consideration of, page 30. He further submit that the Secretary to Government has detained the petitioner under section 3(2)E of the Foreigners Act 1946. That was considered along with other sections of Indian Passport Act and other IPC section. Those were considered and I was allowed to go on bail. Page 32. 13, page 20 at top, your lordship will find the order, 13/2/2025. Detained 6/2/2025 under 3A, and I was allowed to go on bail along with the Passport Act and the IPC section and that detention order under 3(2)E. I was allowed to go on bail on 13/2/2025. Then that order of page 36 was challenged in page 38 by way of a writ petition after I was allowed to go on bail. In page 38, writ petition. Date টা কত? কত? Page 38 at the top, your lordship will find 29/8/2025, the order was passed. Where it stated that I should be transferred to Assam because foreigners tribunals are there. It is so. As you recall, the final order, District of Nalbari State posed this matter after 12 weeks. So when I was allowed to go on bail by a high court, in pursuance to that, whether the trial court here can put me behind the bar under that provision. I was allowed to go on bail. It is only the transfer me from there to here. And when I applied for here, can they put me under detention camp? When there is an order of bail. Well, that is my submission, because if I go through chronologically the dates, I mean, there is an order of bail under that order of under that page 36, I think, 36. And for 14 months, more than a year, I'm in detention. That is my submission, if you want.
No, I am paying from Mr. SSO. No, I am submitting the instruction. Yes. My instruction when today's my instruction. Yes. That is not exactly in the instruction, my lord. I have seen, my lord. Yes, madam. Yes. Yes. Yes, madam. If I am wrong, my lord, if I'm so, my lord, the first order of wherever the Madras High Court, my lord, granted bail, my lord. There's a obvious, is there, my lord, the fact that the petitioner is a foreigner, my lord. Yes. Yes, ma'am. Yes. Yes, ma'am. Yes, ma'am.
Because if that passport does not belong to him,
Yes.
then he can't be kept into custody. Or any offense is done is with the Indian passport only.
We'll convey the message, madam.
Each passing day, he is suffering
Yes, I understand, madam.
jail.
This is neither here, neither there, my lord.
No, you see, every time we can't think of all possibilities in the order.
Yes, ma'am.
The Indian passport you already have.
Yes,
He's
he
also
is having
been
that.
suspected as a foreigner,
Yes, ma'am.
not because of Indian passport.
Yes.
So the inquiry must be held with regard to whatever material you can get in respect of the foreign passport.
Yes, ma'am.
So you will also have to tell them not to limit their inquiry only in the text of the order.
Yes. Obviously, ma'am. I'll convey.
They are the experts in the field. They will tell us how to appreciate a document. And where do we get, Mr. Rajati, where do we get the number of your passport of Afghanistan passport? Where is that?
Indian passport.
No, Afghanistan passport.
That doesn't belong to me, my lord.
No, it's okay, but
But it's in the FIR, my lord, annexure 1, my lord, it is reflected.
It is there, my lord. Page 25.
But there are two passport, my lord.
one is Indian. He's not denying that.
Yes, yes.
One Afghan national, Lahore, Abdul Qayyum, that is male, 0, DOB,
Page 24.
page 25, my lord. Middle portion.
This is Indian passport.
Over one Afghan national, such and such. My lord, with your lordship's permission, if I can say, these things were also considered while giving me bail under the Passport Act. Under the Passport Act, under the IPC, under the detention order of 32E, all were considered in giving me bail.
Indian one. The accused Lahore.
You see, you are in a, what has happened is that once you've got a bail,
My lord.
correct? But that bail does not save you from being kept in the detention center. Because that is not a custodial detention. That is a custody under 3(2),
My lord, there
which
is
says restriction of your movement.
restriction of movement. Here, my lord, if with all, here that order that we have challenged at page 46, 43. 43, my lord, page 45, taking into view the criminal allegation leveled against the proceeding by a competent authority after proper inquiry, procuring more than one Afghan passport with two separate date of birth, such as projecting himself to be a citizen, projecting another name as such and so Nalbari.
You are presently under two charges. Number one, of being a Afghan national unauthorizedly into India, because the allegation is that you have obtained of this, you have entered with a visa. So therefore, that's one. If you're an Afghan national, therefore the procurement of Indian passport is either fraudulent. And if you are otherwise holding a Afghan visa,
No,
then your movements must be in accordance with the terms of the visa.
my lord. I understand, my lord, here, the view taken by the Nalbari Foreigners Tribunal, that it is a criminal case, and that is why I am been given. Page 45, the finding given. Which amounts to tampering with documents, evidence, the prayer for granting bail, for obtaining document support detrimental to the interest of justice. That is, he is taking, it is a criminal case, my lord. Not because of the past having regarding my movement, it is because of my criminal case that he has put me in the detention camp. These charges are of criminal nature. Tampering with the documents and evidence and others. Not restricting my movement.
No, you see, the problem arises not because of that. The problem arises because once you admit that you are having an Afghan what you call passport, then you can be sent back.
No, no,
But you're not wanting that.
no. Because I am not that name of Abdul Qayyum also I am not there. I am Dilwar Khan.
Okay, but that's why we have to examine this to say that whether your passport, which you with the allegation of the passport which you are having, whether that matches with your.
Can there be, my lord, can there be a severe restriction imposed on me by allowing me, but keeping me for 14 months in a,
You understand?
and I am a permanent resident, I will give every kind of documents. I can appear and there, give everything over there. But 14 months, my lord, behind the bar, but virtually in a detention camp. And they keep on going for inquiry after inquiry.
Mr. Roy, you see in our order, paragraph 5. This is the order of 28 January. We have identified the Indian passport vis-a-vis the Islamic Republic of Afghanistan passport.
Lordship.
Now we are wanting the information as to whether these two matches of this there's a match in these two with the petitioner. That is the only inquiry we want.
Lordship.
Now we may be not appropriately correct in using of words in the order.
Lordship.
But what is required is that there must be somebody must come and say that yes, these two passports belong to the same person. Either the iris of the eyes would match or the fingerprints would match.
Lordship.
The passport contains all details which can be otherwise readable.
Lordship. Whether the Afghan passport's fingerprints are there with our
No, may not be there, but you still have the expertise.
Lordship, that I know.
Today, if I do a crime, you have the expertise to find out from this pen my fingerprints.
Lordship.
And my lord, another submission from page 49, Gaumura certificate, my school certificate,
No, we are not.
my birth certificate,
we have no
everything I have
difficulty
given.
with that. The difficulty arises because of that Afghan passport.
My lord. That, my lord, for that purpose, I have sent to the tribunal to prove that I am not a foreigner. For that, if that be the purpose for which I have been sent to the foreigners tribunal, to prove that I am a foreigner or an Indian, whether your lordship will ask for an inquiry or your lordship will see that this order is criminal nature, whether I am entitled to go for bail. That I will prove before the foreigners tribunal, whether I am an Afghan citizen or Indian citizen. If that inquiry is done here, well, the tribunal will be having nothing to do. If there is a finding from this court, well, the tribunal will be closed.
Naturally. There also answers are very.
Indian passport, I think. Indian passport. Afghan.
পাসপোর্টের যেটা ব্যাপার একটু তো আমি চলে গেলে ক্রিমিনাল অ্যান্ড লাইবিং করে করবো করে
এটা তো হলো
যদি আপনি এখানে বলে যে আমি ফরেনার ট্রাইব্যুনাল পরে তাহলে তো এখানে তো কোনো প্রুফ করার কিছু পাইনি। Well. Well,
In the meantime, Lordship, I communicate to them whether this biometrics of that for Afghan and this matched or not. Lordship. Lordship. Lordship.
again, some home tax has to be done. Again, some home tax.
Monday.
In St. Mary's, I used to get some home tax. Two, 3. Obliged.
Obliged.
Well. Fifth. Well. Subject to that earlier 2 days, my lord. Fifth, just after Holi. All right, my lord. On fifth. More time to home tax. Fifth. My lord.
For hearing, upgraded item 15 and 16.
Dinner is on late.
For hearing, upgraded item 13.
The order is at page 36. Starts from page 36.
Yes, Lordship. Lordship has earlier heard this matter to some extent, Lordship. And in this matter, Lordship, the petitioner exhibited one certified copy of NRC 1951, thereafter 1960 voter list, 70 voter list, 77 almost 2010, up to 2010, where her parents' name recorded and grandparents and uncles, etc. name recorded, Lordship. And Lordship, regarding witness, Lordship, she herself and her father as DW2 and two linkage documents she produced before the learned court below. One is Kabin Nama and another is school certificate. The author of both the documents were examined, Lordship, as DW3 and 4. May I take your Lordships to the NRC 1951, Lordship? Anyway, for Paraguay. Lordship. So 1960 is the first voter list, Lordship. Written statement, Lordship. Page 30 starts from page 30, Lordship. 30, Lordship. In the written statement, Lordship, in the written statement, Lordship, she took basically that there was no proper investigation, and she mentioned about those documents, mostly those who were exhibited, Lordship. The documents which were exhibited since 1951 to 2010, and the school certificate and the Kabin Nama. She stated about the entries of their relatives in those documents and about her birth, and the explanation is also there regarding the discrepancies in name of parents, grandparents, herself, etc. Lordship. And she married twice, Lordship. Her first husband died. Thereafter, in the year 2004, she married to the second husband, the present husband. That Kabin Nama, which is pertaining to the second husband, is exhibited as a linkage to show linkage, Lordship.
Where is your school certificate?
Lordship.
Which page?
Kabin Nama, Lordship.
School certificate.
School certificate, sorry, Lordship. School certificate is page, Lordship. Page 66 is the original one, Lordship. Exhibit 1, Lordship. And the type copy is page 65. She studied up to class 4 and left school in the year 1991. But certificate has been issued on 31/12/2016. Here her father's name and mother. Lordship.
Who proved the Kabinnama?
Lordship.
Who exhibited the Kabinnama?
Kabinam I have exhibited lordship.
Who?
At
Who
page
is the
lordship,
witness?
witness lordship, DW4,
PW4.
DW4,
What's his
page
name?
83 lordship.
Hmm?
Page 83 is the statement.
No, give the name.
Lordship, name is lordship Qazi Azahar Ali.
As per this Kabinnama,
Lordship.
what according to you is the date of marriage?
Date of marriage lordship. 1/7/2004.
Yes.
1/7/2004. The date of marriage. It has been issued on 31/7/2004.
Mr. Sharma, you'll have to tell all this tribunals. They break up the documents and then we have a very difficult time in getting the. Not kept in a proper order.
Madam. Yes, my lord. Whatever lordship, my pleadings and the statement in the chief, evidence in chief lordship, has been asserted in my cross-examination also, and my father has adduced evidence. Here also, lordship, if you lordship, there is the cross-examination part of my father. My evidence made in chief has been asserted, lordship, and lordship, the school certificate and Kabinnama, which I have adduced to show linkage with my father, has also been proved in my humble submissions, lordship. So I have been able to prove in my humble submission, lordship. And the burden I have been able to discharge, lordship. Lordship may kindly from 1960 onwards, lordship, link in the voter list also has been established, lordship. Since 1960 and 60 and 70, lordship, my grandparents' name were there. And in the 1977, my father's name with my grandparents appeared, lordship. Thereafter, my father's name appeared. And my name did not appear because I had been enrolled as a D voter. That's why I could not, my voter list, lordship, in the exhibits, lordship. Lordship may kindly have a look in the cross part of the OP as well as her father, lordship. Lordship, documents, lordship.
How are you linking yourself to the projected parents?
I am linking with these two documents, lordship. One is school certificate and the Kabinnama,
School
lordship.
certificate goes, you know the reason. Only Kabinnama remains.
Kabinnama, lordship.
I'm a very badly maintained record. It's very badly maintained record. No.
In my humble submission, lordship, the Kabinnama is able, through Kabinnama, lordship, I have been able to establish linkage because, lordship, the name, address, everything is matching, lordship, in my, as I have projected, lordship. And lordship, there is no doubt regarding the authenticity or genuineness, lordship. The state has not raised any doubt regarding authenticity or genuineness of that documents, lordship. The author was examined, lordship, but no suggestion was put that it was not genuine or manipulated or authenticated, lordship. And the Kabinnama, lordship, my name and address are matching, lordship. And my father also, lordship, what stated in
Which paragraph of your written statement you have introduced this Kabinnama?
Kabinnama, lordship,
Which paragraph of your written statement?
lordship. Paragraph 9, I have mentioned, lordship. Page 31, lordship.
Yeah, ten is. Yeah, 10 is.
17,004. One seven.
In the proceedings, Lordship, my address and husband name was Lordship.
The use of state emblem, it destroys both the documents as non-admissible. The use of state emblem was not authorized.
That's true, Lordship, that he cannot use the state emblem, Lordship. But since
When the link vanishes, you see the reason is that after 77, after 1997, your next voters list is 2005,
Lordship,
28 years.
Lordship,
Is it 28 years? Yes.
from 1997 to 2005, father's name, Lordship. 77, Lordship. But Lordship, address and name all are same, Lordship. It's not that something different has been found, Lordship. Father's name,
You just need a connect. You can connect the two, that's okay. You're relying on two documents, both documents are inadmissible.
and DW2 in his cross, during cross, Lordship, he stated that I have for the first time casted vote in 1977. And that is also projected case also, Lordship. In 1977, with grandfather's name is there, Lordship. And since 1977 to 2005, though there is no voter list I have exhibited, Lordship, but name and other details are same, Lordship. So there is gap, I admit that, but I cannot say that a different person because all details are same otherwise, Lordship. Gauhati দিলেন না লঙ্কা করা নেই কেন হবে Lordship, regarding the use of state emblem, Lordship, what I want to submit before Lordships, that the state prosecution has had the opportunity to discard that documents or doubt that documents or authenticity or genuineness, but that was not raised, Lordship, during cross, Lordship. So it is
Not
it has-
required in an inadmissible document, there's no requirement of cross-examination at all.
And at the time of admission also, Lordship, admission of the
If the
document.
document is inadmissible, it is inadmissible.
Oh.
Even if no objection is raised. Inadmissible document cannot become admissible.
the evidence, Lordship, the evidence adduced by the witnesses, Lordship, are uncontroverted. That's why, Lordship, I am placing on that point, Lordship. Documents very state and the news special.
It's coming, my lordship.
Admission register.
Yes. I think, my lordship, I think. Let's put this, please. In cross examination, lordship, BT. Last para, lord. Page 39, last para. In cross examination, he has disclosed that he issued exhibit 1 without any application to the husband. He. Yes. Yes. Understand of the OP was overwritten and corrected in this figure. Look. This project. Yes, yes. Lordship. Lordship. But their lordship, it is in some overwritten is their lordship. Yes.
Date of admission was 1987.
Your lordship on S column also lordship, it was earlier, it was S column also overwritten and father's name also overwritten, lordship, and these are observed by the learned tribunal.
Please send the document, let us see that record.
And school কথা বলছে, school. Husband of the proceeding.
The logic, why would the tribunal take a, break it up, break the evidence and then put documents here and there?
Lord. Yes, Lordship. Otherwise, Lordship, if document itself inadmissible, Lordship, question of rebuttal does not arise, Lordship, regarding school certificate as well as Kabinnama Lordship, and Lordship Ohavali's case, I am referring in this regard, Lordship. 2018 4 GLT 360. 2018 4 GLT 360. 360. Regarding rebuttal, Lordship, para 16 I am relying. Para 16. It is connected WBC number is 2641 of 2017. Lordship. Ohavali, State of Assam and another versus Ohavali, OHAB. Yes, Lordship. Three six zero. Para 16. On the other hand, from the impugn order, we find that after narrating the case as projected by the Lordship. Yes, Lord. Vote of.
Yes. Yes. According to your lordships, when the lordships are sitting, the 5th of March.
Lordships, 5th of March, Lordships, I have a little difficulties, Lordship. I'll be
12th.
out of station. Either 10th March or 12th March.
12 March.
10th of March. 10th March. Yeah.
I live.
Lordship. 5th of March. Mongolbar purpose of 10th.
Of March.
Lordship. Two matters we have not. 15 and 16 both. Lordship. Okay. But one information has come that the report has been sought from the other district because she is the independent IO. Independent IO has been given to the Lordship. By the time it will be cleared, I think. Because the crime record, she is waiting, the IO is waiting for the crime record from the local police station. If that comes, the letter has been given to me, I am also pursuing, it will be done by this time. True. For submission of the final report, the crime record of that particular person is required. That's true. Well, I have expressed, and to the district magistrate and the SP of the concerned district, they have sent a letter. I am also taking up on it. Once the report comes, she will finalize it. By that, I think by 12, it will be, we'll try. Logic. Manoj. Logic. Manoj.
On 12th, my lord, I will come up. All along.
Relying on para 16, Lordship. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in state of Assam versus Muslim Mandal, reported in 2013 1 GLT 809. Under section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevancy to the fact in issue. By mere filing of documents without examining its admissibility and without the documents being proved, or without examining its relevancy, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevancy. So, Lordship, in this school certificate, Lordship, who has overwritten those overwritten was done by whom, Lordship? That was nobody knows, Lordship. OHAB. Connected WPC is 2641 of 2017. If these two documents goes for nothing will remain.
Lordship, oral evidence of the witness also has to be considered, Lordship, because section 50 will also come. Since my father Lordship. Lordship, I want to place some judgments regarding Lordship consider. Lordship, I'm giving citation and the copies of the judgments. Reported loss. Obliged loss. Case number.